By the way, I do send out the recordings to people who are registered for the webinar. And if any of your friends or whatever want to see this recording, you can always feel free to send it. You don't need to ask my permission or whatever. It's just everything's free here. It's for your own good and the judge is good. So you just send it out as it comes. All right. If you are willing to join me on screen, I would appreciate it on camera. I will begin to screen share and we will chat about some more specific judging things. So yesterday, we talked about a lot of case law stuff. We talked about a bunch of mechanics of the First Amendment and the Fourth Amendment and the facts of the record. I wanted to do two review things because it's a lot, right? It's kind of hard to understand everything on first go. So I'll do two review things, but then today we'll be primarily focused on how to judge around, how to ask good questions, and then how to evaluate and provide good feedback to the competitors at the end of the round. All right, so to review things, I wanted to cover one issue from each amendment. So the First Amendment, I told you that there are three different exceptions to the First Amendment. If you say Mr. Bellator's speech was fighting words, then you're saying that he should be excluded from First Amendment protection. His conviction should stand. If you think fighting words applies, his conviction should stand. If you believe true threats applies, his conviction should stand. If you believe incitement applies, his conviction should stand. Here's the one thing that was difficult probably to process yesterday, which was on the incitement point, which I think is probably the strongest of the three arguments. I mentioned this point about whether intent matters or also the words matter in addition to intent. So let me reiterate this for you. Let's say that somebody intends violence but never says anything. This was the example I gave yesterday, where I said if somebody is about to tell his followers to attack a house, and then in the middle he gets a stroke. So he intends to do it, but no words come out. Should he go to prison? According to the Bible believers test, which is from the Sixth Circuit, so it's not Supreme Court, it's the Sixth Circuit. According to the Sixth Circuit, he should not be convicted because his words were not expressly violent himself. And so if you were to buy the Bible believers version, you would say, well, the words themselves matter. You will hear petitioners likely try to cite for you the Bible believers test. They will say, well, Bible believers says that the words must explicitly or implicitly call for violence. And that helps the petitioner a lot because from sea to sea, Atlanta shall be free. There's not very much that's inherently violent in from sea to sea, Atlanta shall be free. So the petitioner is really going to like that argument. The respondent, they may say, you know what? I'm going to rack my brain and figure out a way to explain how that speech actually is implicitly violent. It's a little harder for them to do. More likely, they're probably going to say, no, who cares about the words? We only care about the intent. So you'll listen to this clash between Bible believers and then more common Supreme Court precedent, the common Supreme Court precedent being Brandenburg, Hess, and Counterman. I'll write that down. Brandenburg, Hess, and Counterman. I'm just going to mute here just to make sure that we don't have any noise pollution here. All right. Let's talk about the Fourth Amendment. The one thing that I wanted to double cover with the Fourth Amendment is the immediately incriminating part of the plain view test. So I said, the question here is not the arrest. The question is the seizure of the gun. Did the officers legally seize the gun when they entered into the room? They saw it in the desk drawer, and then they picked it up. In order to prove if the seizure is valid, two things must be met. Both things must be met. One, officers must have legally entered into the room. They were there either because they had some exigent reason, some emergency pressing need to come into the room, or because they were given consent to enter the room. Either way, they have to be legally present in the room. That's qualifier number one. So you'll hear the petitioner say they were not legally present, and the respondent will say they were legally present. The second part of the plain view test is the one that's a little bit more controversial. This is the one that's immediately apparent. And I pointed out that this is a very interesting jurisprudence question because the question is, do we care if the officer knew deep down that he was underage but didn't think about it at the time? Is that just a technicality? The petitioner is going to may say, well, he didn't remember. And look at the wording of this phrase. It says immediately apparent. There is no room for error, the petitioner will say. The police officer cannot remember 10 seconds after. He cannot remember 15 seconds after. He cannot remember a minute after. It must be immediately apparent that when he picks up the gun, he says, yeah, this gun is illegal because Mr. Bellator is underage. He's not supposed to have this gun. The respondent will say, that seems a little bit too finicky for me. I feel like that's, a matter of seconds. Okay, fine. He remembered it after he picked up the gun. Why does that matter so much? It's such a small technicality. So you will have to grapple with the advocates about whether the timeline, a few seconds, matters or doesn't. Because deep down he knows it, but he doesn't immediately recall it. Okay, questions about review, and there will be a Q&A session time at the end, but is there any questions about anything that we've covered again here? Okay. Let's cover mechanics of the round. So I'll cover mechanics of the round, asking questions, and then evaluating. So let's talk about mechanics of the round. For those of you who have done this before, you'll have to bear with me for the people who have not done this before. So the round begins with a clerk who is typically another parent who is going to introduce you. And the clerk will say something along the lines of, oh yay, oh yay, oh yay, the Supreme Court of the United States is now in session. The Honorable Chief Justice, your last name, presiding. All those having cause to be before this honorable court draw nigh and pay heed. God save America and God save this honorable court. Or God save the United States and God save this honorable court. You next have something to say, and there's a script for you. The script is found in the materials on the website. And you will say something along the lines of, the only case on the docket today that we are hearing is is Taryn Bellator petitioner against the state of Frankfurt respondent. Is the petitioner ready? And the petitioners will respond, the petitioners are ready. And is the respondent ready? And the respondent will say the respondent is ready. I would encourage you guys to have everything set up so that you can say you can proceed without lying. To be honest, there have been times in which I'm reading through the script and I say, you may proceed. And they start talking and I'm still like pulling up my notes and grabbing my notepad and like, then I'm a little bit distracted from the first things that they're saying. So I would encourage you before you say you may proceed to have everything all set up so that you can actually be ready to proceed. The first advocate will ask you for rebuttal time. And unless they ask you for an inordinate amount of rebuttal time, like 17 minutes, you will always just say granted. So what will happen is they will say, at this time, we would like to reserve 3 minutes for rebuttal. If they know what they're doing, they will pause and you will say granted. That's all you have to say, granted. You could say whatever you could also say that's fine or I approve or whatever, but granted is the easiest way to do it. Some competitors don't realize that you're the one who has to grant it to them. So some competitors might erroneously say, like keep going through. They'll say, at this time, we'd like to reserve 3 minutes for rebuttal. My co-counsel will be addressing, and they'll kind of skip it. But assuming that they know the procedure, they should say, we would like to reserve 3 minutes for rebuttal. You will be unmuted and you will say, granted, and then you will proceed after that. So make sure that you grant rebuttal time. And then the next thing to note is protected time. For the first minute of their speech, you may not ask questions. The clerk will clap to indicate that the protected time is over. This actually simulates oral argument in front of the Supreme Court, where the advocate has a minute to present their own arguments before the justices ask them questions. So don't ask questions until the clerk claps. If the clerk somehow forgets to clap, it's not like you're not going to be taken to compliance because you asked a question 50 seconds in instead of a minute in, but just generally try to abide by that minute mark. Okay, of course, as the speech progresses, I encourage you to ask questions and lots of them, and I will talk more about asking questions in a second, but that is, of course, a good thing to ask as many questions as you're able. And if you're like, that's kind of a dumb question, doesn't matter. The advocates will answer that for you. They'll explain it to you. They want questions. I can tell you students' favorite judges are not necessarily the judges who are the smartest per se in any sort of like legal sense of the word, but the people who are engaging with them the most. They don't like judges who are, kind of sitting behind their camera, just observing everything, even if it's a basic question. And you are in charge during this round. You are the king or the queen of the round. So there's no like, oh, I'm afraid to interrupt them. I feel bad. Don't feel bad. In fact, they want to be interrupted. They do, unless they're like really scared of questions because they haven't prepared, in which case they probably won't be excited for questions. But still, you should interrupt them because that's how the Supreme Court works. You can interrupt them mid-sentence. You can interrupt them before they've even started, moving on to the next point. You can ask them to go back. You can even ask them to move forward. So let's say that they're talking about fighting words and you're like, I already agree with you. Fighting words is a bad argument for the respondent to make, so I don't want to hear your argument. You can say to them, Mr. Advocate, or you would say counselor, I agree with you. You can move on to the next point. You can also say, I didn't understand your point. Could you go back? And you can also say, slow down. I didn't understand what you're saying. Like this is your thing. There's nothing illegal about telling somebody, hey, you're speaking a little bit fast. I don't understand what you're saying. This is all available to you as the judge. I want to just encourage you. There are very, very few things that you can do that are like illegal. There obviously don't push this, but like within reason, basically anything that you're saying during the round will be helpful for the competitors to know. So ask questions, tell them to move on, etc. Okay, toward the end of the speech, if they get to the end of the speech and their timer beeps, it should audibly beep because that is a rule that the timer must have audible beeping. I'm going to say this about extra time. Don't allow extra time unless, one, you're really interested, or two, it's your fault. And I'll explain what I mean by this in a second. Okay, so at the end of the speech, they may be in the middle of a sentence and then their timer beeps, beep, 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 beep. They'll stop the timer and they'll say, Madam Chief Justice, I see that my time has expired. May I have a moment to finish what I was saying? Number one, if you're really interested in what they're saying, you can say, sure, you can have a minute of my time. And generally it's going to be about 15 to 30 seconds for them to keep speaking. Also, if you just ask them a question, you're like, okay, counselor, what do you think about this? And then beep, 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 beep. Your Honor, I see my time has expired. May I answer your question? Of course, you should say yes. But let's say that you haven't asked them a question in the last minute. That's a generally good benchmark for me, though you can choose however you want. I say if I haven't asked them a question and I've given them a whole minute and they still are asking me for extra time, I'm not going to give it to them not because I'm mean. I actually like to think I'm a pretty nice judge in most cases, but because I don't think that they should have a strategic advantage. I mean, they're asking for extra time, which allows them to give extra arguments. And if it's their fault, like they didn't manage their time well, they ran out of time and they had to be like, I see my time has expired. I didn't get to finish what I was saying. Well, sorry, you should have probably said what you had to say in a more concise manner. So you can politely say, that's okay, or, no, thank you, or anything of the like. I mean, I personally will just say, I don't think that will be necessary or something along those lines, or we'll just move on to the next speaker, whatever you want to say, but just in a polite way, say no. That's my personal advice, but you can do whatever you want. I just think if an advocate is asking for extra time, it can be a strategic benefit to them when they probably should have just managed their time better. All right, and then we've got the rebuttal. The rebuttal is...
Before you move on, can I ask a question? When you say that we can ask a lot of questions, does that mean, is there any expectation on the judge to have read all the cases that the competitors have read or the complete packet? So are we expected to really know that packet inside and out? So is it a dumb question if we're asking about details of the case that maybe was already, information given at in the packet? You know what I mean?
So the answer is there's technically no expectation that you've read the packet. Competitors would prefer that you read the packet because then you can engage with them better. The packet, by the way, the facts of the record are 5 pages long. That's it. So I think you can probably manage to read 5 pages before the tournament, at least so that you can double check that, you've got all the information down. It is not long at all. The whole packet, which includes the arguments that are made before the trial court, or the appellate court, those ones you don't have to read because that comprises 25 pages. And if you don't get to that, that's fine. You should, and you can, but you don't need to. So is there such thing as a dumb question? No, because the competitors would rather you ask the question than for you to not ask the question, especially because if you ask could you remind me, I can't remember, what did the petitioner say? They're going to be happy to answer that question. They'll say the petitioner said, according to page 6, paragraph 3, blah, 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 blah. And you'll be like, okay, thank you. like that's helpful for them and for you to see if they know the packet. I mean, that's totally fine. But they would definitely prefer that you have read at least the packet. Not the case law is not expected. Very few parents are able to read the case law. So that's why I kind of gave you a quick rundown of case law on our call yesterday.
Ethan,
Yes.
do you have a rule of thumb on how long a question you ask? Do you try to keep it brief to give them as much time remaining on their clock?
That is a very considerate question to ask. And I'm sure that the competitors appreciate it. What the competitors want is a balance between you respecting the time that the finite time that they have, but also they want to understand your question. So if the way that you phrase it when it first comes out of your mouth is terrible, which has happened to me before, I'm like, that's not what I meant to ask. Then you need to keep talking so that they understand your question. They're not going to mind if you clarify your question because they'd rather know what you actually mean rather than,
Sure.
have a few more seconds to answer your question. So just a balance, but I think it's great for you to respect their time in general. Yeah.
Okay. Thanks, Ethan.
Mm-hmm. Okay, the last part of the mechanics of the round is the rebuttal. So the rebuttal is delivered by one of the petitioners. It does not have to be the first or the second. Typically, the first one gives it, but it kind of can flip between either one of them. What you're looking for in rebuttal is you can ask questions during the rebuttal. You can. You are not required to. In fact, you're not expected to. When I judge, I typically don't because I'm going to evaluate their rebuttal based on how well they manage the 3 minutes of time. But you are more than welcome to ask questions in rebuttal. There's nothing wrong with that. I would encourage it. I just personally think that I'd rather listen to their arguments because I'm really into the argument. So I want to know, are they grappling with the arguments right? Are they managing their time well? That kind of thing. But you can totally ask questions during rebuttal. Okay. The mechanics of the round are not too hard. It's really, if you've watched a moot court round before, it may seem a little bit intimidating. The competitors are probably more intimidated of you than you are of them. So you asking lots of questions is a good thing. They want to hear as many questions as possible. There is no such thing as a dumb question unless you ask it in a really arrogant way. So as long as you don't ask it in a really arrogant, abrasive way, then there is no such thing as a dumb question because they would be happy to clarify for you. All right. Speaking of asking questions, the second part of this talk is about asking questions. The bench brief that I drafted for NCFCA this year is available on the website under Judge Resources. So if you want to read through the bench brief, it will do the same thing that I just did where it overviews the case, and it will also have a list of sample questions. So if you're like, to be honest, I don't really have questions of my own, but I want to help out the competitors and ask questions, read through the bench brief before you start so you can kind of think, what are some questions that I kind of like here? By the way, some creative questions in the bench brief are asking like small adjustments. Would it change anything if XYZ? It's like what we call hypotheticals to say, what if Mr. Bellator had sworn during the riot? Would that have changed anything? And this isn't because it will help you decide the case. It's because you're trying to see how well do these people think. Are my competitors that I'm judging, are they just kind of reading through their script or can they think outside the box? So if I say to them, would it change anything if he swore? And they say, oh, that's not the point of this round, and then keep talking, clearly they're not willing to think outside of the box that they've constructed. If, on the other hand, an advocate says, Your Honor, I don't think so, one could possibly say that that would be considered obscenity, but there is court precedent that says obscenity is typically sexually explicit material. And swearing typically is not violating the free speech, the First Amendment, because people swear all the time, and that doesn't mean that they go to prison. So I don't think it would change anything if he swore. Now you're like, wow, this guy can actually grapple with my questions. Like he can think outside the box. So that's a nice question, is just a hypothetical. Like, what if we change this little bit? Would that change anything? And just evaluate how well they're able to go around your hypotheticals. So I'm going to put down bench brief so you can read through the bench brief. What I'm calling hypothetical, well, it's not just me, but what are called hypothetical questions that change little parts of it. A good thing for you, if you're like, I really want to not just ask the stock questions in the bench brief, is to ask one side about the other side's arguments. And all this requires is that you're a good listener. So let's say the petitioner says, I think that hot pursuit doesn't apply because there's this one case called Lang. And in Lang, they said that hot pursuit only applies in felonies. And you're like, huh, well, we know that this isn't a felony. So if the petitioner is not lying, if they're telling the truth about that case, and Mr. Bellator isn't a felon, doesn't that mean that hot pursuit doesn't apply to Mr. Bellator because he's not a felon? As you're thinking about this, one easy way to ask a question is to ask the respondent what they think. You can say, how would you respond to the petitioner's claim that hot pursuit only applies if you're a felon? And now the respondent will have the opportunity to say, well, that's not quite exactly what Lang said, Your Honor. Lang said that it certainly applies in the case of felons, and it may apply in the case of misdemeanors. So petitioner was misspeaking just a little bit here. So that helps you evaluate, grapple with the arguments. You can go back and forth. How would you respond to this argument that they said? How would you respond to this argument that they said? That kind of thing can be very nice. And all it takes is listening well. Also, asking them why. So say that they say, the Supreme Court has said that it doesn't matter if a person is offended. All that matters is if the person intended it to be offensive. You're like, what? That seems weird. You're saying you're going to invalidate what their thoughts are? Now, your first thought might be, well, that's what the Supreme Court said, and that's good, because it's true. If that's what the Supreme Court said, then you have to agree to it. But you can still press them and say, do you know why? Why would the Supreme Court say that? Why would the Supreme Court say that because it's offensive to one person, even if it's offensive to one person, it doesn't matter as long as the intent or whatever that point is. You can just push them and ask them, why do you think the Supreme Court said that? Another one, and this is good, especially if you are you are grasping the materials decently well. You want to ask them why they didn't address certain issues, or if they could make an argument on a certain issue. So ask about other issues. I'll give you an example. So let's say the respondent says, Your Honor, I will be arguing that Mr. Bellator's speech is incitement, and I will not be arguing that his speech is true threats. I will not be arguing his speech is fighting words. It'd be a really good test to see if they've read case law to say, well, if you were to make me a true threats argument, what would that argument be? That's a great question, especially because you can kind of snuff out the people who read one case and were like, all right, that's all I need. If they've read the case law, they'll say, Your Honor, my argument is not true threats, but I could pitch you on an argument. I would say that his speech is a true threat because under the case of Counterman versus Colorado, the court established that a true threat is only requires that the speaker have a conscience moment. And the speaker did have a conscience moment because anyone with more than one brain cell would have realized that his speech could be threatening to the people in front of him and therefore could be true threats. That's just not my argument today, Your Honor. My argument is incitement. You're like, wow, this guy really knows his stuff because he's not just one-track minded on incitement. That applies to the Fourth Amendment too. They say, Your Honor, I'm not going to raise a consent argument. I understand you're not going to raise a consent argument, counselor. I'm just curious, if you were to raise a consent argument, what would it be? I'm telling you, it's a good question for you to evaluate how well the competitors know, especially in high-level rounds. You know, maybe if you've got some newer competitors and you want to go easy on them, it's very nice to just, ask them some softball questions. If you're like, these competitors seem like pretty decent competitors, I want to tell who's better than the other one, ask them these kinds of questions. What would you say if you were to make XYZ argument? All right. And then this last one is ask about the implications. In philosophy, we call it the reductio ad absurdum of their argument. And this requires some critical thinking. So let's say that the petitioner says, hot pursuit doesn't work. The police could not use hot pursuit to pursue Mr. Bellator because he wasn't a felon. Now, if you don't know much about case law, you're like, no, I guess I agree. But think about it critically for just a second. Just think about it. If that's true, that means that the police cannot hotly pursue somebody who's not a felon. So that means if it's a misdemeanor of assault, a misdemeanor assault, like domestic violence is a misdemeanor, you're saying that the police cannot hotly pursue somebody? You're saying that if, the police see somebody shoplifting, something that's like $200 from a store, they cannot hotly pursue them? That's what you're saying, isn't it? This is where you have to do some critical thinking. You have to say, if this is your position, and we applied it everywhere, is that a reasonable position? Would I say that, yeah, I'm willing to accept that that's reasonable for every case? Here's another one. The petitioner says, Clearly, the officer, there's no exigency, because exigency means emergency or pressing or urgent, because the officers walked to his dorm room. If it was really urgent, they would have run. Now, when you first hear that argument, you might be like, huh, sounds pretty decent. I think I kind of buy it. But critically think. If I applied that in every case, I'm saying the police always have to run every single time there's an exigency. So you're saying if you ever see a police officer walking, he's not allowed to have an exigency. So in the case where, like, you know, a guy got shot in the leg downstairs and he looks up and he's like, oh my gosh, someone's shooting bullets. If the police ever walk to that house, then it's not valid anymore. Now they have to get a warrant. What? That seems a little bit cockamamie. So here's where it takes a little bit of critical thinking to say, are you really going to say that walking is so, you know, you can never walk? If you walk, then that means it's not an emergency. You can walk in emergency situations. That's totally possible. So think about the implications of their view and see if it always works. All right. The last part is evaluating. So when you're evaluating students on the ballot, as I said yesterday, you aren't voting for whichever side you thought won the round because maybe you're biased. Maybe they had the case packet is biased toward one side or the other. So they don't make you vote for which side you like. They say, which advocates did you think presented the best? And here's the criterion. They're on a scale of 1 to 10. You can give them between 1 and 10 stars on these 5 categories. Organization. Argumentation. Knowledge. Response. And delivery. Okay, let me give you a couple of hints here on how you can think about these 5 categories. Of course, you are fully free to evaluate the round how you like. In fact, I encourage you to evaluate the round how you like. Please don't just take my advice just because I think it's how I judge, but people judge differently. I think at the very least, most people should judge at least according to each category, and then you weigh each advocate on the same category. So the best way to fill out the ballot is not one speaker and then you fill out all the categories for that speaker, but actually to go across the board. So you say, okay, let's compare organization. First speaker, how is his organization? Second speaker, how is her organization? Third speaker, how is her organization? Fourth speaker, how is his organization? You do organization all the way through, and then you do argumentation all the way through, knowledge all the way through, response, delivery. That way you've got real comparisons instead of going top to bottom on each speaker. Here's what I'm looking for, and I'd be happy to actually hear if you want to pipe up things that you look for as well. As I'm going through this, feel free to raise your hand and interrupt me. So organization, what I'm looking for is intro. Oh, wait, I should do it this way. A nice intro, an intro that's compelling. I listen to it and I say, wow, that was well crafted. It wasn't like they took some time and thought into making it sound rhetorically pleasing. I like to think about ending on time. This is truly an organizational moment, right? You've got 8.5 minutes to talk about a complex constitutional issue. Did you manage your time well? If you ended up not covering one of the issues that you told me you would, like let's say that you said at the beginning of your speech, Your Honor, we present 2 points, consent and exigency. And then the only thing you talked about was consent. That means your organization wasn't so good. Don't blame it on yourself. Don't say, well, maybe it's because I asked too many questions. The competitors are good enough where they can always move on to the next question. Unless you're being rude to them, they always can say to the next point and then just start talking about their next point. Think about a competitor. They've got a script, but they can always jump around from different parts. So if you ask them a question about this, they could jump around here. They can cut this part. They can move on to the next part. So don't ever blame yourself if they're not ending on time, unless, you asked a question and you gave them like 15 seconds to answer it. Then, that's not their fault. Definitely not their fault if you ask them a question, right? That's something that comes to mind for me, but it's up to you. In general, a general split between issues is good, though this is not a universal truth. But like if they say I'm going to cover consent and exigency and they spend 9 minutes on consent and 1 minute on exigency, that shows that they did not have very good organization. Same thing in rebuttal. And this is a key thing to look for in rebuttal. You can do this to help evaluate, is to set up your phone and check their timer. and set, a stopwatch counting up for 3 minutes and see how they do with their time management. A 3-minute rebuttal should be split in half, a minute 30, a minute 30. Most times people will cover 2 minutes of their own issue or 2.5 minutes of their own issue, and then 30 seconds of their partner. Because they'll be like, yeah, to be honest, I don't really know my partner's issue, so I'm not really going to cover it. And lots of judges let them get away with it. And me, when I'm listening to their speech, I'm like, you covered your issue for 2.5 minutes because you didn't know how to address your partner's issue. So I'm listening in their rebuttal for the time management to see, are they spending a good amount of time on both issues, or are they spending all their time on their own issue because that's the only one that they know? That all has to do with organization.
So you're talking about the second speaker that closes up. He should be basically concluding for both.
Yes.
You're saying?
So the first speech, assuming a 3-minute rebuttal, because each team gets 20 minutes of speaking time. So at least respondent gets 10 minutes, 10 minutes. 20 minutes of speaking time minus the rebuttal time. So if the petitioner takes 3 minutes of rebuttal, that leaves them 17 minutes, which means 8.5 on each speech. In the rebuttal from the petitioner, they must cover both issues. They're rebutting both respondent 2 and respondent 1. So they should be using half of their time on each issue in general, about half of their time on each issue.
I see.
That's a great comment to be looking for to keep people accountable, to not just fake their rebuttals. Yeah. Okay, argumentation. To be honest, this is where your expertise is going to be different from mine. It's just like whenever you're listening to their argument, are you persuaded that they picked the right one? To me, I'm going to say, I don't really like fighting words. I don't really think that that's that good of an argument. But if they say something that's banger, they're like, you know what? I've got this case law that you didn't even hear about that actually, says this and this. And I'm like, I never thought about that. I'm going to give them props for their argumentation. I might give them a pretty high ranking on argumentation. In contrast, if somebody says, you know what? I'm going to cover consent as my only argument, and they don't even make very many good arguments. They're like, consent is good because, the police officers can kind of do whatever they want. I'm like, that's not a good argument. So I'm not going to give them high on argumentation. It's just listening for the argument itself. Did they pick good arguments? Like, are they using the right arguments? I'm going to say incitement, but I'm also open to true threats. And I'm also open to fighting words if they give me a good one. But it really depends on the kind of argument that they pitch to me. So I'm not really going to say much about, did they choose the right one? Did they choose persuasive one? Choose persuasive arguments.
Sorry, dumb question. So you're saying that they don't have to address all of them. They can just focus on one, and as long as they have backup for why they chose that one. Is that what you're saying? So they don't really have to go through all of the arguments?
Yeah. So the unfortunate fact about Moot, which I talked about yesterday, is that the respondent is like the AF team in TP. The respondent, the second people to speak, these guys are like AF, and these guys are like neg. Now, AF gets to choose their case, just like in TP. So the respondent technically gets to choose which of these 3 exceptions they want. So I talked about these 3 things on Fourth Amendment, these 3 things on First Amendment. These 3 things on First Amendment. The respondent gets to choose which one of these they like. So you should be thinking like, hey, did the respondent do a good job of picking the argument that I thought actually was persuasive to me? You know what? They chose fighting words and I liked it. Or they chose fighting words and I hated it. I don't know why they tried to use fighting words. That was a bad argument. The petitioner, they don't really have as much of a choice, because if you can imagine going neg before an affirmative even speaks, you're like, what do you even say? You kind of have to cover everything. But there's still a little bit like, did they choose a good, what we would call in TP a spike? Spike is when you respond to something before they've said it. So that you say something like, the affirmative will probably say XYZ, and then you spike it. When you listen to what the petitioners are saying, did they choose good responses? Because there are multiple things that they could say in response to the respondents. Did they choose good ones? It's just listen to their arguments. Did you find it compelling? Did they choose good arguments to respond to and to address themselves? Thanks for your question.
Okay.
Okay. The next category is knowledge. I love the knowledge category because it does separate great teams from not so great teams. There are 2 things that I'm looking for in the knowledge category. One is case law and the other is facts of the record. Now, don't just like a team because they said as much case law as possible. It has to be, if you ever met somebody who says a lot but you don't really understand what they're saying. Maybe you would call them knowledgeable, but that's kind of an annoying person to be around. You don't have to rank them high in knowledge. So like just because they spitball a lot of case law at you isn't a good thing. What is helpful is when they say case law that you understand and they reference a reasonable amount of case law. It doesn't have to be a ridiculous amount. I'm not going to give you a number because it totally depends on the round. That's where you compare them to their competitors, right? That's why you don't compare them in a vacuum and say, you're just a 7. Like you have to compare them to the other people in the round. You referenced a lot of case law and I understood it. This guy did not reference any case law. I just didn't understand what he was saying. The second part is the facts of the record. And here is a great way to distinguish people who I would call more fraudulent with people who are actually knowing their stuff. Do they give specific citations? Oops. Do they give specific citations? So let me pause my screen share for a second and show you the record. So I've highlighted my version of the record on the facts of the record part. So it's, as I said, it's about 5 pages. It starts on page 3 of the packet. So we would say this is page 3 of the record. This is factual and procedural history, the official record for the court. This is paragraph 1. This is paragraph 2. This is paragraph 3. Now, if you're asking somebody a question on First Amendment and you say, Counselor, I feel like this statement is really violent, and I don't know why you're protecting him saying from sea to sea Atlanta shall be free. That's really violent. Like originally it meant violent things. And the competitor says to you, Your Honor, it isn't really that violent because the record says that it really just meant figurative patriotic sentiment. That's fine. That's acceptable. Now listen to a different interaction. The judge says, Counselor, I feel like it's really a violent slogan to say from sea to sea Atlanta shall be free because originally it meant like wipe out the Olympian people. That's like genocide. And counsel responds to you, Your Honor, according to page 3, paragraph 2 of the facts of the record, the statement does not mean genocide. It means, quote, the elimination of the Olympian state from the island. And according to that same page and paragraph, it refers to the government multiple times, not the people. So I wouldn't say that this is genocide. I would say that this is more likely referring to the government. Key difference here. At the very least, they gave you a page and paragraph. They said it's page 3, paragraph 2. Now I know they know their stuff. They're not just like, somewhere in the record it says that. Same thing with this. If you say, Counselor, since Mr. Bellator's friends all had like brass knuckles and Bowie knives, don't you think that Mr. Bellator is a dangerous person? And they say, well, Your Honor, the record says that he's not a dangerous person. Any old schmo can say the record says, because you just have to say the record says. It would be a lot more impressive if they say, well, Your Honor, according to page 4, paragraph 2 of the facts of the record, Mr. Bellator didn't engage in any violence. Even though, according to page 6, paragraph 3 of the record, many other Olympians threw bricks and stones and harmed other people, the record explicitly says on page 4, paragraph 2 that he didn't engage in violence. So I'm citing specific pages, page 4, paragraph 2 of the record. This is paragraph 1, and this is paragraph 2. That's how I know this guy's not just saying, the record says it, but he's giving me a specific place. That means he's read the record. He knows it like the back of his hand, or she. Because these advocates, I mean, if they're doing their prep, they should know it. In fact, when I'm walking my students through this, I'm having them memorize the page and paragraph of each of these paragraphs because I want them to know this so that they're not just saying, the record says that. Because as I'm saying, you could very easily lie and say the record says this. It's a lot harder when you have to name a specific place so that the judge could check you hypothetically. And if you wanted to check them, you totally can. Okay, that's what I'm looking for in the knowledge category is case law and then
have you ever judged anybody where they got the case wrong? Maybe they just misremembered which case it was and they so do you, like, as a judge that hasn't read the cases, like would we, we wouldn't know if they said something wrong or even if they quoted the packet and we don't exactly know what paragraph it is, like, do you check on them or not really?
Yeah, you couldn't really check them on case law. That's why you've got a handful of judges who do, and hopefully they're just going to be academically integrous. And that's why some judges do read the case law, and some alumni judges read the case law. And I know like Henry Chen reads the case law and that kind of thing. I read the case law. So that's, if you can't check them on case law, that's totally fine. You can check them on the record though. So if they say, according to, let's see, page 6, paragraph 2, Officer McLeod recalled that the gun was in the drawer, or sorry, he recalled that Mr. Belcher was underage only after he picked up the gun. And you say, according to page 6, paragraph 2. If you really wanted to double check them, you can just go to page 6. Let's see, page 4, page 5, page 6, and look, paragraph 1, paragraph 2. And indeed, it does say, according to the SIS e-board information, Officer McLeod recalled that he was under 21 years of age, and that comes after he says, after the record says that he photographed, seized, and opened the bag. So you can fact check them on that. That's the only thing you could. You don't have to. I mean, that could be distracting to you. You could also do it later if you wanted to. I just like trust if people are going to give you a specific citation that they're willing to back it up. They're willing to let you fact check them. So in more cases than not, they're going to be truly telling you something from the record.
Okay.
Okay, so we've covered knowledge, response. There are kind of 3 things that I'm looking for in response, although again, it's up to you. I'm looking for direct responses. I'm looking for length of answers. And I'm looking for feeling satisfied. When I say direct responses, what I mean by that is, if I say, isn't it true that Mr. Bellator had posted on social media before from C to C free? And they say, Your Honor, according to the case of Terminiello versus Chicago, this court held that even though speech is inviting dispute, that's the exact purpose of the function of free speech. What the heck did that say anything to that question? A lot of people will do this. They'll start with case law, yes or no. If I have a yes or no question, I want a yes or no back. Why believe this? I want them to say because this. Like I want them to be quick to my question as possible. That shows me that they're really, really ready to grapple with my question, not reflect by trying to get to a different piece of case law. That's not always the case, because sometimes you'll ask an open question like, what do you think of this? And of course they can say, according to this case law, that's totally appropriate. But in general, I'm looking for direct answers. In general, I'm also looking for a good length of answers. If it's too short, then that means that they probably don't have that much to say. If it's long, then they're not covering their arguments well enough. So just a reasonable amount of time in responding to the questions that I'm asking them, which is related to feeling satisfied. Like if you ask questions and you're like, yeah, I kind of would rate that like a B- level answer, versus the other advocates are like, wow, they're all A+ answers. That's kind of how you're thinking about with responses. How satisfied were you feeling when you responded to your questions? Okay, delivery is the last one. And in general, just things that are befitting of the court. You are imagining that you are in the Supreme Court of the United States. You are a Supreme Court justice wearing a black robe. You are sitting behind the booth, and the advocates are standing up in this great hall with tall ceilings and marble pillars. I mean, this is the Supreme Court simulated. When the advocates speak, they should speak in a way that is befitting of the court. That means that they should not be speaking super fast. In general, they should not be using colloquialisms. They should not be tagging their points like this is a debate round. They shouldn't be saying, my second response is incitement. Like, this is not a debate round. Could you imagine saying that in front of a Supreme Court justice? Like, this is not debate. If you see oral advocates using too big inflections or getting angry, like the things that are not befitting of the court, even hand gestures are like a little bit too much for the Supreme Court. The Supreme Court generally would prefer you to not even use hand gestures at all, because the main argument is supposed to be just an oral argument. You're not supposed to be persuading them because you have such great nonverbal communication. So even hand gestures are generally frowned upon in courts of law. So in general, you want to listen for, of course, typical public speaking things like not saying is obviously standard, not using filler words and filler phrases, but specific to Moot, things that are befitting of the court. Did they speak with a certain level of respect for the court? That doesn't mean that they can't be pleasant. In fact, I hope that they are pleasant. In front of the Supreme Court, they, you know, the justices will sometimes crack jokes. It's just that they should speak in a way that's respectful. Another thing that I like to look for in delivery, although I suppose this could also go in response to this, so this is kind of how you prefer it, is the transitions between the responses and then their own case. So if you imagine they are delivering their prepared speech, and then you will interrupt them with a question. And when they finish answering the question, you don't have to tell them, okay, go back to your speech now. Like they're not a little kid. It's like, imagine a college professor. If a college professor is giving a lecture, student raises his hand. Professor, what do you mean by this? The professor will answer. And the student doesn't have to say, okay, you can go on now. The person just keeps talking. So listen to the transition between the responses and their case. If advocates will say, you know, does that answer your question, Your Honor? That's not really a nice transition. They should just be transitioning back into their case. In certain instances, I suppose it could be helpful if you really wanted them to. But sometimes, you know, they didn't answer my question and they say, did that answer your question? And I'm like, no. That's not really going to be helpful to them. But, you know, that's why I generally recommend that, you know, you focus your transition less on like, hey, Your Honor, is it okay if I move on? Why are you asking for permission? Just move on. Just like finish answering the question and then start speaking again. The smoother the transition, the better. That also aligns with delivery. Oh, okay. I had one more thing under direct responses. I wanted to point out this with direct responses. If you hear competitors saying the same thing and you are bothered by it in their responses, then you should look out for this. So let's say that every single time you ask them a question, they say, absolutely, Your Honor. This is my answer to your question. So you're like, why do you believe blah, blah, blah? Absolutely, Your Honor. I mean, if you're not annoyed by that, then don't be annoyed by it. But like personally, I want my questions to be answered not with an absolutely. If I say, why is this happening? I want them to say, because of this. I don't want them to say absolutely. Same thing with yes, Your Honor. You know, if I say, blah, 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 do you agree with this? And they say, yes, Your Honor, I'd love to answer that question. Just answer the question. Don't tell me you'd love to. So small things that would like separate people who are like decent. Because sometimes if you've ever watched a moot round and you're like, dang, everyone's just really good. I don't know how to separate, you know, the greatest competitors with the not so great competitors. Just look for some small things like how quickly are they getting to your question? Are they using filler words and filler phrases? Yes, Anne.
I have a question that piggybacks off of David's in the chat, and it's related to how you assign number points. We were just talking about this earlier at club, and I know like in Coolidge debate, they will tell their judges like, this is a general point range, you know, like you're probably not going to see a debate, you know, a mooter who's getting ones in every category. Like, do you have a sense of what that average range is?
Yeah, mine is not unofficial, but it's just from reading students' ballots. The average is typically around 7.
Okay.
So if they're an average speaker, they're a 7. If they're slightly below average, they're a 6. If they're pretty below average, they're a 5. And only if they're like really, really bad would I give below a 5.
Okay, awesome.
Which can happen. I mean, hypothetically, you could get someone who's like stumbling through the whole speech, doesn't even know how to answer questions. Like that's technically possible. Don't be afraid to give 10s if you think that they were outstanding, but you know, 10 is certainly a high bar, I would say. Yeah. Of course, don't like take my word as gospel. This is just what I've seen from ballots. This is what I'm, you know, when I'm looking at competitors, I'd say the average is like 7 with my, you know, the good students, they're getting 9s and 10s and 8s. With the slightly below average students, they're getting 6s and 7s and sometimes 5s in very rare cases. Yeah. Okay, that's it, guys. That's everything. So we did some review on Bible believers in Brandenburg, and then on the plain view test. I talked you through the mechanics of a round, and then a couple suggestions for asking questions, and then evaluating competitors. We've got time for Q&A. Any questions you guys have? Anything from case law to evaluating to secret questions that I have, etc.
How do you take notes during a round, Ethan, as a judge? Like, what is your flow strategy like?
I put it on my notes app because I can type faster than I can write. And I will usually, when I'm listening to their roadmap, I'll put down their roadmap so I can just remember their arguments. And if I have anything to add to that roadmap, so like if they're like, oh, if they make an argument that I'm like, oh, that's pretty unique, I'll just add it next to the roadmap. Everything below will be comments that I liked or didn't like. So I'll say, to remind myself, like, great pace, or this guy spoke too fast, or this person did not have direct responses, or I did not like this person's response to this question. So it's like each person is kind of categorized on my notes app: name, roadmap with any comments next to it about the roadmap or about the speech, and then things that I liked and didn't like underneath that. Yeah. Other questions?
Ethan, do you have an example of that roadmap that you use?
Oh, so yeah, I mean, I'll show you what I did with, yeah. Okay, so I just did I judged a practice debate with a few people. I have the name up here, and then the roadmap is right below it. So I'm going to say, for First Amendment, I'm going to say, he told me he would address true threats, TT. He told me he would address incitement, and he told me he'd address violence. I already deleted my comments for him, but if I have any comments for him, I'm going to put it here, like spoke too slowly,
Gotcha.
to smile more, that kind of thing. And if he says something really unique, I'll say something like, he said under true threats that he does not need to prove counterfeit. I don't know. That doesn't mean anything to you, but that means something to me. So I'll put that down in this, which is all the content of the speech. Next speaker, I'll do this. She told me she'd address consent and exigency. I'm going to write my comments for her right here. So Simon told me he'd address incitement and true threats. Solomon told me he'd address legal presence and legal seizure. And then I've got my notes down here. That's basically what I do.
Gotcha. All right. Thank you.
Anyone else? Other questions? All right. Well, silence indicates mastery. So I'm excited to see some masterful judges out there after this weekend. I'm of course kidding, but I would like to say to all of you, the students are very grateful for judges who ask questions. They're also grateful for judges who just show up and judge them. So they're grateful for you regardless. All judges are equal, but some judges are more equal than others, as they would probably say to you. But your contributions are very important to the kids. So, as I said to my mom who asked earlier, there really isn't such a thing as a dumb question. A judge who keeps their mic on mute the whole time is the judge that the students would not like to have the most out of all the judges. So even if you're like, just asking them some clarification question, the basic one that I told you, the easiest one, if you're like, to be honest, I feel kind of lost, listen hard and then ask the other person to respond to the other argument. That's the easiest one. So just listen hard and you're like, okay, I heard them say that Lang says that hot pursuit doesn't always work. I'm just going to write that down. I'm going to ask the next person. Okay, the petitioner said Lang said hot pursuit doesn't work. How do you respond to that? Just reckon with it that way. That's some of the easiest questions. But yeah, lots of questions as needed. But don't feel pressure. You are going to be a good judge because you are going to give them good feedback. And any questions that you give them will also be good as well. All right. Thank you all for being here. I'm glad that you have joined me today. I hope you have a great experience judging. I love judging moot court, and I think you will love it as well. See you guys later.
Thank you. Thanks for doing this, Ethan.
Very welcome.
All right. Absolutely, Your Honor.
Absolutely, Your Honor.
Thanks, Ethan.
See you guys later.
All right. Bye.
Oh, David, did you have a question? Maybe not. Okay, go for it. You can unmute if you'd like, if it's faster for you.